My name's Tracy DeBeer. If you've got any queries related to the administrative side of this workshop, if you could just speak to me. Our higher education and further education colleagues to engage with open educational resources and open educational practice. And as part of that, we run a number of different events throughout the year. And this one on Creative Commons will hopefully be able to answer the questions that you've got. So other than that, I'll hand you over to Jason. Jason's from Just Legal, and he'll be taking you through today.
Good morning, everyone. A full day of law. I'm a firm believer in the positive aspects of working with law and copyright, and I'll come a little bit more to that in a second after introducing myself. Yeah, there I am. That's in full regalia. I'm the Just Legal Service Manager, have been for 7 years now. If you don't know Just Legal, we are a body funded to assist further and higher education with the legal issues that might otherwise be a barrier to new technologies. So we're about getting rid of barriers. That's what we try and do anyway. Of course, some may say as lawyers that we're trained in causing problems and raising barriers, but no, we try and get rid of them, is what we do. We are pretty much, well, for most of our activity, the core activity, funded centrally, for the moment anyway, which means that we're free at the point of use. In other words, you've already paid for us, so you may as well use us. So I'm here today, hopefully, for this. We certainly believe utmost that our job is to help you. So if you have questions, then use our help desk. Please have a look at our materials. We have a whole section on open educational resources, as well as feeding into other people's materials as well. As you'll see, anyone who wears fluorescent green leg warmers probably isn't shy. I'm happy to take questions and heckling as the day goes on. Matter of fact, I'd positively invite it, because I'd rather go away knowing I've answered the questions and concerns that you have, rather than me talking at length. I've had some great workshops where we've actually just ditched the programme and spoken about what people want to know. So if questions are going to come up, then no problem with that. If you haven't switched your mobile phones to silent, I don't care, unless it's a crap ringtone and it's copyright infringing. Well, that wouldn't be particularly great either. But yeah, please do chip in as we go along. We will be using voting pads today, yeah, I'll show you how we use them. I think you might have used them before, but it's pretty easy. You press the number corresponding to the answer that you're going for. If you press the wrong one, you just press the one you want afterwards, and the previous one will be overwritten. So pretty straightforward, as long as this all works down here. For me, the goal of today is you going away with strategies that deal with, for a start, the legal reality. There's some things we're not going to get round. You can ask me all you like, can you use other people's stuff without their permission and include it in the OER, because it'd be great. And it really doesn't matter how great it will be, but there's no getting round the fact that copyright says that a copyright owner has got control over their productions, over their works. And if you don't get permission, you don't have anything else that helps, then you can't use it. That's the legal reality. There are strategies to get round that, and we'll be discussing those as the day goes on. Of course, I think I work from a viewpoint as well that actually an awful lot of stuff that's produced, people do actually want to share. Sometimes they don't see that, and that is not useful for us, not helpful, because the legal default is that if people don't say they want to share something, then it isn't by default shareable. You need to ask and then get permission in some way. For my background, so you know a little bit about that, I was 10 years a lecturer in law. That's before including head of department for a while. That was fun before I decided that I'd had enough of bureaucracy. Anyway, I was one of the ones who was, I suppose, an early adopter. You're all probably too young to remember the days of the OHP with the tablet that you put on top of the overhead projector, which weighed half a ton. You connected it to a half-ton laptop that had a battery life of about 30 seconds. It needed its own minor power station to power it. But back in those days, I could see the value of the technology. And it was one day when I had a class of 300 students doing business law. And I'd worked up loads of online learning materials. And actually, I saw loads of them in the library, spending hours actually on this multiple choice quiz that I'd created. And it was because it was interactive, first of all. It was because it was a bit of a bugger, this test, because they got through it, they'd get something like 70%, and they think, I'll do it again and get 100%, but it was a bank of questions, so the next time they did it, it was different questions. So, and they were all striving to get 100%, and they spent hours on it, the way they would play some of the PS games and or whatever. So, and that was, I would never have held their attention for that length of time as a lecturer, no matter if I was a kilt-wearing lecturer bouncing up and down the lecture theatre steps, occasionally tripping. But anyway, we won't dwell on that. But anyway, so I could see the power of that. But what I did wrong back there, and again, this fuels my passion that I have for sorting out copyright and open educational resources in education, is I spent huge amounts of time paraphrasing other people's stuff, recreating materials that had already been created. I think of I did remember one year, about 30 overnighters in the university, creating materials for the virtual learning environment to give stuff to the students. And I look back with horror, like, what a waste of time. I should have been using other people's stuff. And funnily enough, like, as someone who was dealing with intellectual property rights, it was a cultural thing that was blocking me, not a copyright issue blocking me. But if I'd got past the cultural issue, then I would have dealt with the copyright issues and used other people's stuff. It would have been more efficient. It would probably have been more effective. There are people that would have been better at me at writing the materials. And I would have had much more time to concentrate on the important bit, which is the interaction with the students, providing the context in which the materials can be used. So I think I learned a lot from that. And actually, when we deal with copyright law at Just Legal, we tend to call it using other people's stuff online. Because that's really what we're talking about. Here we're slightly different because we're talking about taking other people's stuff quite often and repackaging it and putting it out, or taking our stuff and making it available to the world. And indeed using other people's stuff that they've made available to share. So we'll be dealing with all those aspects today. Oh, that's the Just Legal website. Hopefully you'll visit that. Range of stuff organised under a content management system by role, by legal area, because we like to deal with legal areas, but we know that you prefer themes, so there's a theme area. OER appears under themes, and also it's just going off the screen to the right, you can just see Open Educational. And that's under projects as well. Again, part of our credentials, we have been involved in the support for open educational resource programmes run by JISC and by the Higher Education Academy jointly. We've just finished phase 2 of that. I know some of you have been involved in that. Phase 3 coming next, and we do that in collaboration with Web2 Rights. Again, it's a consultancy that assists in this area, and also with Creative Commons UK, so we're working with them too. So we've been doing that. Part of that over the last year has been responding to inquiries to our help desk. Last year we got some 60, 70 inquiries to our help desk, as well as doing events and such. So hopefully we have an idea as to the questions that are on your mind. Again, that's sometimes we have to face the realities. Other times we can find ways and strategies to deal with those. All right, today you've got a programme, so I'm not going to belabor this one. What you need to know about copyright for OER. First of all, there will be a question coming up about gauging your knowledge of copyright to start with, because if you know it all, I'm not going to teach grannies to suck eggs. But there's some background needed there. And actually, there are some things that need thought through a little, and again, reminding. Even yesterday in the Just Legal office, we were talking about the interplay of performers' rights and recording rights and phonographic rights. And we had to scratch our collective heads in the Just Legal office as, well, at present we're 3 lawyers and that have been working in copyright for a long time. But in order to get to the right answer with regards to extension, as it happens, of recording rights and performers' rights, then we had to go through all the issues. Great fun. Getting to know Creative Commons, again, you'll probably know something about that, but again, going to explore the repercussions of different Creative Commons licenses, the interoperability and the interplay between them. Choosing a Creative Commons license, the consequences. Something we've been through at Just Legal, we've changed our licensing. Again, there's the question now of we're moving on to a maturity now about open educational resources, I feel, where we've had our initial go at choosing licenses and our appreciation of the consequences. We're now seeing the real consequences, some of them unintended, and now we can work on being a bit more mature. And again, I will explore that. Lunch, and then including other people's stuff in your OER. By far, that is the biggest issue that we've come across in Just Legal. So we've got a generous 2 hours put aside for that. I can tell you the answer just now to the question of somebody hasn't given us permission, can we use it? And the answer is no. That's pretty much it. So, and actually, every time I try and find examples to bring this home, I come back to the physical world. And I always think, if I'm, say, an art tutor, and I want to create an installation which is a battered Ferrari, a spanking new Ferrari beat up to show, I don't know, some interplay between violence and modern materialistic society, then my first question is going to be, can I get hold of a Ferrari to do this? Well, it's installation artwork. And what we need to get people to realise that if people decide they want to use a Walt Disney cartoon as part of their teaching, the first question has to be, how on earth am I going to get hold of a Walt Disney cartoon? And again, it's the same sort of thing. I think the thing that's moved on, and the thing that these issues have come much more to the fore, are two things. First of all, technology and the access. But also the second thing is, as a result of that, and independently, the value in intellectual property is much more appreciated than it was before. Once upon a time, those producing stuff, books, CDs, DVDs, whatever it may be, any copyright artwork or any work, they generally sold the physical medium. That made life easy and treated as goods. You want to sell a CD, you sell a CD. But now the CD's disappeared. We don't really deal with the physical media. If you're talking about music, what you're buying is the right to listen to music. And obviously the business model has had to change of those producing. The values have had to change as well. And some of the debates have come more to the fore. Again, I love the creative subjects and dealing with them. That's in areas. And the one that I love is you always get a member of staff and you'll say to them, what do you think about plagiarism? And they'll say, that's terrible, stealing other people's stuff, shouldn't be allowed, should be chucked out. And you'll say, how do you feel about using other people's stuff in your teaching? Oh, we should be allowed to use anything that we like in our teaching, and that should all be fine. How do you feel about people taking your stuff without acknowledging or paying for it probably? Oh, that's terrible, that's theft, this is my livelihood. And trying to get them to link up these things is sometimes a little bit of trouble. But yeah, there's increasing focus on the value of intellectual property and the rights. And it won't be very long now, surely, before when we buy a song, we won't buy a file, or we won't even buy, or certainly not the physical medium. What we will be buying is simply the license in some form. And my mobile phone now, I can get access to just about any song I like. That's on my mobile phone. The right to listen to it is the thing that people are going to pay for one way or another. Interesting questions obviously coming up about enforcement of copyright as well with this current government's progress. Anyhow, back to this. So including other people's stuff in your OER is going to be the key area, unless you tell me otherwise. Top tips for avoiding OER IPR trouble. In 15 minutes, I'm going to bring it down to try and bring it to the nux of what will actually help. And then a couple of case studies, though I've actually included quite a lot of scenarios all the way through, and final questions and more, perhaps wider discussion, if you're still here. Now, this is Friday, in case you haven't noticed. We've got a workshop on law till 5 o'clock. I've been around in academia long enough to know that not everyone might be here at 5 o'clock. So, as a test of the voting system, get things going, that's there. Of course, it's anonymous. Let's admit, if you all press number 5, then we're in trouble. We're going to go for this as a test of the voting system, and also allow me to know how to pace the day's workshop as well. Now, you'll see that up in the top right-hand corner very closely, the red will turn to green. Technology, should never use it. Repoll this question. There we go. Well, you can now press your buttons. And it should tell me you've got 16 votes so far. How many of you are here? 5, 10, 15, 22. So hopefully 22 responses. That's brilliant. Press your buttons now. What are we going to get as an answer to this one then? It takes a few seconds to count up the answers. Oh, look at that. Oh, you're a star. Look at that. 2/3 staying to the bitter end. I'm on a 6:13 train, which is an advanced ticket I'm stuck on, so I'm here to the bitter end. So that's it. Okay, nipping away a few minutes early. 4 p.m. train was cheaper. Yeah, I hope that's someone joking. But you never know. Okay, right. I'll be here the full day certainly. That's and 2/3 of you will have better access to me at the end when those have gone shopping or train catching. Any questions there to start off with? Comments? Okay, that's what you need to know about copyright for OER then to start us off. I will say before I get here, copyright and knowledge of copyright is actually a fascinating subject. That's, of course, I think it's a fascinating subject. That's, one thing I reflect on is that having been a lecturer for 10 years, at no point did the institution actually see fit to train me in copyright, which I find bizarre. They trained me in fire extinguishers, and fire extinguishers again, and they trained me in stress management, time management, project management, more stress management, and stress management. I wonder why that was. But never about copyright. And it's weird, I was about to spend my academic life using other people's materials. To be effective, then I would use other people's materials. I was tottering on the shoulders of giants, I think, maybe. But yeah, no guidance on that. And as I gave the example before about the amount of time I put into reinventing the wheel, recreating materials, then that was a waste of time and money, and I learnt a lesson from that. And so I'm very evangelical about getting people to use other people's stuff well and put the extra value on top. And actually, it's still the case, hopefully less so, that up and down the country today in academic offices, there'll be a load of people paraphrasing other people's work because they feel it should be their material that's up there, not someone else's. Sometimes because it's a direct thinking, I can't use that person's stuff, I can't just scan it and put it up onto the VLE because that would be infringing copyright, so therefore I'll go and paraphrase it. It goes on a lot, unfortunately, it's a waste of time. Also, quite interesting, I like the whole science of paraphrasing. It's something, I was, in my early days as a lecturer, I was kind of confused. The student had written, I was teaching European law at this point, put that the European Parliament needed to give its assent to the termination of international agreements. And I'm thinking, I don't think that's right. Where did that come from? And so I thought, I better go and check this. And I looked through, and I found the phrase in one of the main textbooks, the European Parliament must give its assent to the conclusion of international agreements. And I thought, only in English can you have a word, conclusion, that can mean the start and concluding an agreement, and indeed the end of stuff. But the student obviously hadn't understood and just paraphrased conclusion to termination, which is a kind of a change in the meaning. So, yeah, careful in paraphrasing. But we want to get away from that. If we can use to the best other people's stuff and then put our bit on top of that, then we move things on, and that's where we want to get to. So using other people's stuff productively is going to be the way forward. Right, here's the question I promised you about intellectual property rights and copyright. Could I ask you to guess or take a shot at whether you would say you're confident, I have a fair idea, I dabble, I ask others, or I hide in the toilet. If you want to press your buttons there. See, the voting pads are great because whenever I do it by hands up and all the rest of it, nobody ever puts their hand up to I'm confident, because that's asking for trouble, isn't it? And nobody really wants to say that, well, some do say that they don't know anything. Very few would say they're hiding in the toilet at that point. But okay, let's see what we've got here then. Oh, we've got a countdown timer. It's amazing the things you can do with these, but if I'd only remembered to press the button 10 seconds ago. But the tension, it's just like press your buttons now. One of my colleagues who was at an American conference whereby they had the voting pads, and when a certain proportion of the audience had pressed their button for no, the speaker stopped and was dragged off the stage. I thought, interesting way of doing conferences. Is that coming up? Yes, there we go. All right, we're just about a bell curve, though. We have got just under a quarter of the audience hiding in the toilet. Right, that's okay. All right, well, luckily enough, my next slide is copyright in one slide. So there we go. That will get us up to speed with that. Okay. It's magic when I do this and everyone's confident in there. I think, what am I going to do for the rest of the day? But anyway, that's something. Right, here's my copyright in one slide. This is copyright. About, I reckon, 3/4 of the questions that were asked at Just Legal about copyright can be answered by going through these 3 points. First of all, there's an appreciation that copyright controls copying and other restricted acts. That's adapting, communicating to the public, in other words, disseminating stuff, performing in public. Those sort of things are controlled by copyright. Not prohibited, but controlled. And it's up to the person who produces or who creates the copyright work, and then the person who owns the copyright to decide what can be done with it. If you want to do one of the restricted acts, such as copying or one of these other things, you must own the copyright, and if you do so, then everything's straightforward, or you must have the permission of the copyright owner. There are a few education-relevant exceptions, statutory exceptions, but they apply to pretty defined circumstances, and they're not any sort of general right to use in education. You may have come across the term fair use, and it's an American concept, and that's a wider educational use right. We have a fair dealing right, which is much more restrictive. It's a personal right for research and private study, and it doesn't allow multiple copies or communicating to the public at large, so generally doesn't fit in with open educational resources at all. We do have a fair dealing right as well with regards to criticism and review, and that's one of the areas where we do have some leeway in open educational resources, where we are critiquing other people's work, or we are reviewing other people's work. If we do that fairly, in a way, then we can use other people's stuff. And that's why we can include quotes from others in work, and that's how we get on. That really does it. People ask me, can I, of a languages department, can I take our old cassettes and transfer them onto DVD? I say, well, the stuff on it, are you the copyright owner? No. Do you have the copyright owner's permission? Well, not yet. Well, you're going to have to get it, because that's in making an adaptation, a copy of it as well. So that's what it comes down to. So, yes, then.
I was just wondering, your question was about how do we feel about IPR,
Yep.
intellectual property rights. This slide's about copyright, and I'm just wondering, is there a distinction between IPR and copyright? I thought there was a slide.
Yeah, certainly, absolutely.
What it is.
Yeah. Today is mainly focusing around copyright because that is the most important area for us here. The previous slide did ask about intellectual property rights in general. Partly that's because...
Kind of supersede copyrights or subsidies at all.
Yeah, absolutely. Copyright is one of the rights. There are related rights to copyright that we can't ignore as well. Moral rights, performance rights, various exploitation rights as well. They're all good fun. And they end up as layers of rights, and that causes us no end of bother in some instances. But yes, intellectual property rights includes patents, trademarks. Trademarks sometimes come up as an issue with regards to open educational resources. And there are 2 reasons before my question before. The IPR slide is there so I can use it in other presentations. And also IPR is shorter than copyright, so it fits in. No, but good point and well made that is copyright we're pretty much dealing with here. I'll mention some stuff about the other rights that can be impinged upon or have to be taken into consideration. Pretty much trademark and registered rights and design rights later on, but towards the end. But copyright is the main issue here. We are talking about the right to make available the materials. That's the definition of an open educational resource, one that's shared for liberal use under a Creative Commons license, and that's the domain of copyright. Thank you. Yeah.
Sorry, I probably missed it. Can you explain what restricted acts are?
Yeah, sorry. Restricted acts are the list of things that the copyright owner can control. The main one is copying. So if I have a copyright work, I can control who copies it. There are other ones beyond that, though. The right to lend materials out or rent them out. The right to make adaptations is a very big one for us, or translations of works. The right, and again another big one for us, is what's called communication to the public, and that means making available to the public at large, putting it up on a website, making it available for download in some way, shape or form. Performance in public also is another one, or showing in public. Broadcasting is another restricted act. These are all the things that the copyright owner can control. Sometimes people get confused about, or they forget that that's it. So see this bit of paper here, this is a copyright work here. The way it's been laid out at very least, it's got a way of doing it. It's probably, it could be argued it only contains information otherwise, and therefore that is not a creative work otherwise. But the way it's been laid out, even though it's a simple thing like that, it still benefits from copyright. I can give this paper to anyone in the world with impunity. That's the right to actually give this bit of paper to someone is not a restricted act. I'm not copying, I'm not adapting, I'm not communicating to the public at large.
But do you have to have the permission of the names mentioned on there?
I'm not going to deal with data protection. That's another issue that's in terms of this. And yeah, there would be an issue. Yeah. Yes.
Excuse me, question related to the last one. You were talking about distribution on websites.
Mm-hmm.
What is the difference if the website is actually password protected and can only be accessed by the students and tutors on a particular course?
None. I love it when a lawyer can come up with a one-word answer. Well, I'm afraid the definition of public for the purposes of copyright and intellectual property rights is a very narrow one. There is some, again, that's when, of course, there's always a depends involved in one-word answers with lawyers. But one thing to be said is that I'm only talking about about the restricted acts. You can have a license that says you may use these materials, but only behind a password-protected area on your website. You may only use this for a certain group of students or in a certain context. To comply with the license, then, you must use the password area, or you must restrict it to those students. A license can have any terms it likes, and you must comply with it to be compliant. However, when we're talking about what the restricted acts are, the fact that you are communicating to 2 or 3 persons, or 1,000 persons, or 10 million persons, doesn't make any difference for the purpose of what a restricted act is. Communicating to the public is any number of people. There is a very interesting question, again, in the Just Legal Office. We were debating earlier this week as to whether one person can be the public. And it's coming up with the PRS and PPL, the bodies that license the playing of music in public. That's universities, indeed, will have a PRS and PPL license, both. But there's a question that's come up with a jeweller's shop that's where the back office is only used by one person, and is the owner-operator, the sole trader in the jewellery business, and whether that is actually in public or not. PRS and PPL say it is, by the way. That's no, I'm not convinced. But anyway, that's we'll do that talk another day. But certainly, when you're talking about a group of people who are an arbitrary selection, if you like, outside the domestic arena, like that's then you're talking about it. So you don't control what students come onto a course. They are the people who are there. That's the public for the purposes of the restricted acts. So. Going back to the example about giving this bit of paper, one of the things that people find difficult to understand intuitively is that if I get the Harry Potter book, I can give it to my friend, and they can give it to their friend, and so on and so forth. And there's no copyright problem with that whatsoever, reading it. Whereas, of course, if you get an e-book on your iPad, Kindle, or whatever, and then transfer it onto someone else, and then rip the DRM and stick it up online, so others can use it. That is a copyright issue because you're making a copy. And whereas with the Harry Potter book, when you're handing it around, you weren't making a copy. So it's sometimes that doesn't seem to make sense when because quite often even the publishers are trying to promote the parallel between owning a copy and owning the e-book on your Kindle. But legally there's a difference.
So is that if you want to use somebody else's material, is that the same as in an online context, putting a link in rather than embedding something?
Okay, well, again, linking in itself is not a copyright restricted act, which is good news. Or else life would become a lot of fun. There was actually a case about 5-6 years ago where BT, looking through its archives, found that it filed a patent years ago, but still valid, well, still within the term of the patent, for basically hyperlinks, hyperlinking. And that was a fun case because it really was a very little chance of success. It was too widely framed, the patent, and as you would have heard a lot about it if it had been accepted, but it got rejected, the validity of the patent, or else we'd all have to pay royalties to BT for every hyperlink. Yes, that's the destruction of society when it happens because of this. No, that got chucked out, but linking. There's, I think, Section 28A of the Copyright Signs and Patents Act says that by the technological process of getting stuff from a server to your computer, looking at it, then that's all fine. So even though when I'm looking at a web page, then technically my machine is making a copy of that. Technically, there's probably a cache in between as well, taking a copy as well. That's all provided for in law, thankfully. We don't need to worry about that. The only things that it does say, there is a part about economic significance if you link in a way which bypasses commercial elements or the look and feel of a website or important notices, then you have the legal issues of what's sometimes termed deep linking, and deep linking in a way which bypasses economically significant elements, to use the technical language. Best example I came across of that was up by Manchester, at a university up there. There was a lecturer who had decided that he was using Guardian news stories, and he found that if he went to the print version, it got rid of all that Guardian nonsense around the outside. And so he was linking to that and framing it within the VLE so it looked like stuff that he had sorted out himself, and removing most of the Guardian stuff. That isn't on. The print version is given for a particular purpose. You can't just link to that straight off. But on the whole, linking is not a restricted act, and even the copying that occurs is provided for under Section 28A if you're interested. Any further questions at the moment? We've dealt with the whole of copyright. Yes.
Well, who is the copyright holder in some cases? Must be.
Yeah, that's
you're referring always to academics here, but I would think the institution, in most institutions, have an intellectual property statute which says that teaching material are owned by the university.
I avoided that issue because it wouldn't fit on one slide. But I will be coming to that and over several slides, in fact, and yes. One of the big issues with OER is knowing who can give permission for it to become an OER, and also when you're getting permission to use other people's materials, to know who can give permission. Because I'll tell you, I'm great at giving permission for you to use other people's stuff. Except if it is other people's, then I probably can't give you permission. You go ahead, use Walt Disney stuff. Unfortunately, that doesn't work. That's in the same way. Use that Ferrari out there, beat it up. That's fine. No idea who owns it. Ownership is a very good point and needs to be taken into account. So the question of you must own copyright or have the permission of the copyright holder. If you have, again, the question of if you have the permission of someone who's not the copyright holder, well, you can just go through our steps here and you see what happens. There is no permission, therefore no right to reuse, and that can be a pain. Because sometimes people don't tell you they're not the copyright owner as well. And actually, one thing about today that we have to deal with is the concept of risk. And risks, I love, whenever risk comes up, it's this nasty. The risk is not a certain thing, and I love certainty. Certainty's good. I like licenses because licenses are generally certain. But when it comes round to risk decisions, that's something that has to be taken with regards to decisions on copyright sometimes in OER. And so we have to look at that. So, for example, if I write something, this morning for my own purposes, and you ask if you can use it this afternoon, and I say yes, there's no guarantee whatsoever that you can ever get that I didn't transfer my copyright late morning to someone else. I'm just not telling you. You cannot get certainty. You have to live within the world of that risk management. So it's interesting. And admittedly, we do it all the time. I would sometimes ask, how many of you have driven at 31 miles an hour in the 30 zone? That's a risk we choose to take. We assess that, hopefully, and take that. And we deal with that. I was interested that sometimes we don't actually appreciate or let people take their own risk decisions themselves. This morning, actually, I was staying in the Premier in town, and there was a notice above the tower ring, caution, this may be hot. I'm thinking, well, isn't it supposed to be? Well, and you'll have seen many of the signs before. That's our appreciation of risk and how we do it is interesting. And again, with university principals and senior management teams, again, there is this sort of gut reaction that say, right, copyright, how much risk do you want to take? None. Let's don't want to take that. I said, you've got power tools out there in the car park. And you've allowed those into the premises. If I ever have to choose a fight between power tools or copyright infringement, I'll take copyright infringement every day. That's rather than fighting with power tools. So that's they have to appreciate it. And again, part of the strategy that has to be developed for each institution is to look at mission statements. And if you are an institution that's choosing to base itself on a local 18-year-olds coming into the institution and daily lease builders, then you probably don't need to take an awful lot of risk in copyright. If you plan to be a world leader in distance education or education anywhere, then you are going to have to take some decisions which are more at the upper edge of the risk spectrum and live with the consequences. And we all, we do that all the time. Who owns the copyright? So you led me into that slide nicely there. That's well, again, try and keep this simple. The author or creator is in general the owner of the copyright. However, that rule has more exception than actual abeyance of the rule in academia, because on the whole, Section 11.2 comes into play, and that's where a person is employed and creates materials or copyright work in the course of employment, then the employer will be the first owner of copyright unless there's an agreement otherwise. Now, so that means that, that when I, as a lecturer over 10 years, was making up all my materials and slides and all the rest of it, then actually, as they were being created, I was never the copyright owner. The first copyright owner was the institution as my employer. We had no agreement otherwise. That is difficult for some to accept. It's an area of tension quite often, and that's in academia I've found. I had a colleague who was well up on intellectual property law, but at the bottom of every PowerPoint slide, he had copyright in his own name. He just couldn't face the fact that it wasn't his. That's, it was, again, he knew about Section 11.2. I think the way forward, again, I'm not an expert in industrial or employment relations, but again, the way forward is discussion and getting certainty beforehand. We do suffer a little bit in higher education, but to some extent further education as well, about the lack of clarity in contracts. Contracts tend to be fairly vague statements of what's to be achieved. It generally isn't particularly simple to say that job that Jason did at 10 o'clock was within his course of employment, that thing at 11 o'clock wasn't. Okay,
sorry to interrupt.
Yeah.
So if you're using an open educational resource and you've adapted it and you've released it under the same share-alike, can be remixed license,
yep.
What does your employer have over that?
Right, if who has released it as...
so you, say, for example, I took something from Open Skies, which
right.
is Creative Commons.
Uh-huh.
I adapted it for
Yeah.
my class, and then I re-release it under the same
Yeah.
license. Doesn't that go back to that original?
Right, what happens is you've still always got the original resource that's there as
Yeah.
part of OpenSpire, whoever's created that. Your adaptation has a new copyright in it and a new Creative Commons resource. If you did it within the course of employment and there's no agreement to the contrary, the institution will be the one that's licensing it out under the new Creative Commons license. If you've done it not within the course of employment or you have an agreement otherwise, it will be you personally that's re-licensing it under that. Whether that matters or not tends not to be high up the scale. One approach is that you both agree to that, so the institution gives its backing and the academic does it, so it doesn't matter who owns it, someone's done it. There's a valid Creative Commons license one way or the other. And the other way of looking at it, and again, it's not a legal analysis that's been carried through very often, is that actually you could be acting on behalf of the institution anyway. So when you make decisions, you're actually acting as the agent of the institution. So it is the institution in any case. Whether it's the owner, it's you that gets to make that decision about licensing out. So, so hopefully that can avoid the issue. The issue tends to be where you've got pre-created materials that the institution wants to license out on Creative Commons and the academic doesn't, or vice versa.
Sorry, I'm just trying to understand what the course of employment is.
Right, yeah, good. That's,
What exactly is that? Because I'm trying to think, if I did something at home,
yeah,
does that count?
it can. That's, right, place and time doesn't matter.
Right.
That's and whether you are doing the activity for the purpose of fulfilling your contract of employment is what matters.
Okay.
That's a bit of a bugger. That's because, as I say, contracts of employment tend to be pretty vague. In this. So there's various ways of going about it. The first thing that is certain is that it's not a case of when you start at 9 o'clock in the morning, everything you do till 5 o'clock is in the course of employment. That's I used to work beside a guy who used to sit and play. I was an old-style solicitor and used to play solitaire from 4 o'clock till 5 o'clock. And be-thereism or whatever, presenteeism or whatever. But yeah, so it's not just that. And it's not even whether you use your own materials, your own resources. If you're at home using your own computer, doing your own researches, the question is, are you doing it for your in the course of employment? You get the problems when things are both towards course of employment and for your personal thing. I go on holiday, I see something, I'm an archaeology tutor, I'm personally interested, so I take a photo, but I also have in mind that this will be great for next Monday's class. Where does it fall? That we've never had it, we don't have any case law to guide us within that. I think, again, a court, if it came round to it, would be looking at the primary purpose and would have to make that difficult decision of which side of the line it falls on. You also have the situation, mostly more in FE than HE, where people work for two employers and do things for both employers at the same time. Again, we've not had the statute doesn't deal with that. We've had no cases. The chances are there'll be joint ownership between the two institutions, which means that both have to agree to anything being done. Yes, sorry.
I'm just saying, because I've had to do a bit of digging around for this in my institution, digging, searching and finding things, and could find nothing in contracts at all, really.
Yep.
But I found it in the end it was in the intellectual property guidance that was from the team who do the things like patenting new inventions. So I sort of tracked it down in there, and luckily there was a good description, because obviously if you read it in sort of black and white, so the academics were like, that's it. You know, it belongs to the institution, but they never ask for it. So do you know what I mean? It belongs to them, but they don't. Yep. They don't know what you do. You know, they don't
exist.
So the penny is dropping with these repositories, because they never ask for it, but it's there, so you can imagine. But what was good was it had a really good description of, okay, yes, it is ours. However, while you're here, you know, it's ours. When you move, we're happy for you to take it with you, because obviously it's your work. And then there was various things about that I think they wouldn't adapt it once you'd left, but they'd like to use it. So there was quite a nice, you know, it had been thought through and sort of discussed. So it's worth digging around to find that. But the only thing is, of course, you never find that bit of information unless you dig it out. But I think with the Creative Commons and repositories, we'll need a bit more. Bring that to the fore, but I was so pleased to find a reasonable description of it for that institution. You know what I mean? Otherwise, you just don't know who owns it. They own it. They don't even know it's there. It's quite strange.
Do you think that's standard, the information that she found?
There is a whole range. You get institutions that haven't tackled the issue at all, that's and have nothing on it. You have again. One of the danger things that your answer there actually rang a little bell is IPR guidance is sometimes given out with these things here, but that's not an agreement. That's so it is one way. The university's view of what it should be, not incorporated in legal terms into the contract of employment. Therefore, you have an issue.
Yes. I was going to say at the Open University they're very tight, and the lecturer's contract is very specific. And if I write a book, I can have my own copyright and that thing. Anything else, any computer software, any inventions, anything, it's the university's explicit copyright and what to do about it. And it's all there.
Although I did see, I think it was, I don't know, dare to say it's Imperial or someone in London that had given copyright to academics. They'd given it the other way around.
That's why I made a
So
distinction between IPR and copyright, because at our university you would say that the author, the academic, has intellectual property rights, but the copyright is owned by the university, who then gives a non-exclusive perpetual license back to the academic. So it's clearly saying the university owns copyright, but we give it back to you, which means you can take it with you, but what we did here stays here.
And are they actually
And we
using
can
all
exploit
these
that.
Creative Commons things for that?
Well, this is what I'm just
Yeah.
writing notes about, saying now, I think our intellectual property statute, because it was done, revised probably 5 years ago, is silent on the Creative Commons. So who is giving the right to license it under Creative Commons, because the university probably doesn't even know.
There's two approaches to that. First of all, it's sort it out, but unfortunately that can sometimes lead to, well, it's led to industrial disputes at Cambridge and Trinity,
Yes.
at least. I'm sure there's others that have been through fairly difficult times trying to sort out the issue. The second one is the sort of blunderbuss approach, get everyone to agree, so it doesn't really matter who owns it. But actually, going back the one stage further from the guidance in that is, as you've said, sorting out the relationship well. And Just Legal has assisted, particularly a school of music and a conservatoire, where the issues are very pronounced, because obviously the ownership of that sort of creative work, the music, the recordings that went on, is obviously something the staff and the students were very passionate about. But as you said, the way they got around it is realising that, well, someone has to own it, and then there's two ways. Either both can own it. Actually, you have joint copyright ownership. That's messy. Much better is having one person or one body owning it and licensing to the other everything they would want to do with it. And that's what they managed to get to. And in the end, actually, the discussion between staff and the institution, in both cases, decided people didn't really care too much about who owned it, as long as the other one could meet their uses, because everyone was happy. So, and that's possible. I think, there's going back to the original question, there's a whole range of practice across universities. 5 years ago, I published a study on IPR and student work, and there are about a third of universities that are then, anyway, 5 years ago, that were claiming IPR and student work. That's through their statutes, and that I have no doubt that will be struck down if ever that's challenged. So a third of universities actually had invalid statements trying to grab student IPR. That's and unfair terms and consumer contracts regulations applied.
Yeah, my son's going to Lancaster University, and as part of his registration, there was a question. You were assigned copyright, and the default it was checked and things, and you had to check it just to say you wanted copyright.
I won't divert off this, but the unfair terms and consumer contracts regulations say in order for that to be binding, it has to be fair. And let's can you imagine the student ever being in a situation saying, actually, I don't agree with that, I'll just go to another university, bye. I'll just get myself out the hall of residence, I've been here a week already. I'm sure another university will just let me in down the roads and 2 hours notice. It's not going to happen, so it's not actually a fair choice. The PR departments, external marketing departments, loved it when I said, well, if you're going to do this, you're going to have to be upfront in your prospectus that you want to take all the students' IPR. I said, well, we'd rather not include that. That's so funny enough. But I find it very interesting. So often, obviously, part of my job, I end up in an awful lot of institutions around the UK, and I go there, and everything seems to have a barcode on it. Actually, we're not bad here, but if you sit too long in a chair, you end up with a barcode on you and part of the asset register. Whereas they won't tackle the issue of who owns the academic intellectual output, which surely is the crux of the institution. So one of the things that they will help open educational resources is moving this issue up the the management scale, because until you know what you own as an institution, you don't know what you can do with it and who can do what with it. And of course, you will have the cases where people, for whatever reason, want to take stuff with them or remove it and all that. I actually had spent a while one day pondering whether I could use the delete key on my laptop, because as I type stuff for work, then that wasn't mine anymore, it was the institution's. So I'm allowed to delete it. And obviously the answer is that deletion isn't actually a copyright restricted act. So I can do that. Or am I making an adaptation of it? Then again, I dare say I can act as an agent of the institution in deciding what I do with it. These are the things we think about over lunch and just